Item number 3.
May I please, Your Lordship? Your Lordship, in this case, I have filed the affidavit for the status report of the service upon the response.
Item number 4. Yes, Your Lordship. So should I have instructions to appear for respondent number 2?
You'll be entering appearance today.
Today, Your Lordship.
What is this matter about?
Your Lordship, we have filed for application under Section 482 for quashing of the FIR, which is the offshoot of the civil disputes, whereas the party has agreed enter into an agreement for supply of SE organic bag, and in connections to that, they have lodged an FIR, which is not maintainable.
So you are seeking quashing of that.
Yes, Your Lordship.
You are appearing for the complainant.
Complainant.
Can come up after 2 weeks, Lordship.
Yes. You will be filing your objection.
No,
Will you be? Okay. Mr. He'll Mr. So appears on behalf of respondent number?
Number 2 is for respondent number 1.
Respondent number 2. There is only service is completed, it means.
Yes, Your Lordship.
Service completed.
Let the matter be fixed for hearing after 2 weeks.
Is one thing hard so and so for the petitioner and hard so and so and so and so. Then you say so and so appears on behalf of the respondent number. Respondent number 2. As pledged for by the Honorable Counsel of the number 2. Reach this matter after 2 weeks.
2 weeks, Your Lordship.
You wanted 2 weeks, is it?
Any day, Lordship.
Tomorrow?
2 weeks.
After 2 weeks. This can be hard, no? This is matter is ready for hearing. Then
Will be ready for hearing.
shall we list it for hearing or do one thing? So and so enters appearance. Then you say, as per the submission made by the parties, list the matter for hearing after 2 weeks.
Hearing item number 8.
Yes, Mr. Day.
May I please, Your Lordship? My Lord, if my Lord recollect, this is a matter where the respondent was directed,
Oh, that backlisting.
backlisting, my Lord.
Yes.
My Lord, my instruction I placed on the last occasion. The instruction dated 26th October 23.
You were supposed to give a copy to
Yes,
Mr.
yes,
Day.
they have supplied us a copy on the very day. So they are not into that point what we was, my Lord, that whether they are going to recall the blacklisting from the date of issuance, my Lord. Otherwise, again, I am barred technically. My Lord, other things, they say no comments and yes, Assam Rifle has no objection for the same. So we are not into that, my Lord, and this matter has to be decided on merit, my Lord.
My Lord,
Have you kept your instruction? This thing, have you furnished it to us?
just keep this one.
So they are not recalling that order.
No, my Lord. So I am agree with that, my Lord.
My Lord, my instruction, my Lord, is that debarment was permanent, my Lord, in the order, in the impugned order, subject to review after 2 years. If I may take your Lordship to the...
If something is permanent, what is the use of review then? What it would imply?
My Lord, if Lordship kindly turns to the impugned order as it stands, my Lord, that is at page 56, my Lord, of the writ petition.
Yes. Page 56.
My Lord.
Yes, yes, page 56.
My lord, clause D, my lord. Messrs. Lamonte Enterprise is hereby banned from business and debarred to enter into any business dealing with Assam Rifle, with liberty to seek review after 2 years commencing from tomorrow for restoration of business dealings as hitherto for.
Yes. So you are saying,
my lord, 2 years are over, my lord. We have, though he has not, my lord, it can be recorded, my lord, that
2020, 2 years is over already.
2 years is over, my lord. And my lord, it can also be recorded that now, since 2 years period of blacklisting is over, my lord, we have not extended it beyond that, and he is free to participate in our bids also, my lord. Even that can be recorded, my lord.
So that will not satisfy Mr. Day?
No, I'm not satisfied. I want to go into the merit of the case. First and foremost, my lord, whether they have the right under the general finance rule, my lord, to debar me forever. My learned senior has read out clause D of the impugn order. Whether they have the right, the law doesn't permit them, my lord. It is technically for 2 years only, my lord. There is no question of reviewing or not reviewing, my lord. And we want, my lord, this order to be set aside, my lord. Because this is creating problem for me to participate in the future tender also, my lord.
My lord,
They may not have any problem, my lord, but what about the other departments, my lord? Recently, my lord, Assam Police has called for a tender, my lord. I cannot participate because they wanted an affidavit whereby, my lord, I should declare that I am not debarred from participating or I have not been blacklisted.
Debarment is only with regard to entering into business with the Assam Rifles, not with other.
No, my lord. Here, whenever the tender is floated, my lord, that they used to ask for an affidavit whereby, my lord, I have to swear that I have not been debarred to participate in any government institutions or establishments, my lord, in the last 5 years. So that will create problem for me, my lord. And now, my lord, my blacklisting was proper or not, that has to be adjudicated by this honorable court, my lord.
Your challenge is to the order dated 27th May in the writ petition, Mr. Day.
27
May. Is it? That is what your prayer says?
27 May order is the impugn order, my lord.
Yes. That is the only thing impugned.
Yes, my lord, that is the only thing impugned.
Where is that order?
This is on page 50, my lord. Actually, 11.
This court has forgotten everything.
No, I will not. So, my lord, I will take my lord from the beginning, my lord. I will take my lord from the beginning.
Yes, you'll have to. Just try to.
The relevant portion is on page 55, my lord.
Just let us get the facts. The court's here. Oh, it's a big order.
The big order, man. The relevant portion is on page 55 only. In fact, they have quoted the show cause notice, they have quoted the law without any reasoning, man.
But this entire project stands cancelled, isn't it?
Yes, yes.
Then what relief ultimately you may get if you are successful?
My only intention is this, my lord. They should compensate me. Second is this, my lord, that I should not be debarred from participating the tender in future tenders, where, my lord, because of this affidavit, which will create problem for me. I cannot swear an affidavit on lie, my lord, because they have blacklisted me, and they are the government institution, my lord. And there is a stigma also, my lord, whereas there was no mistake from my end.
Here they are asking for recovery from you.
Yes, yes, they have filed a suit.
We filed suit.
How this, you have already filed a suit.
They have,
Then how this court will decide that thing? That is cannot possible.
no, about the suit and all, my lord, about recovery and all, my lord, I am not insisting this honorable court to pass any order on that. I am only on this blacklisting, my lord, whether my blacklisting was correct or not, my lord.
So your issue is now confined to the blacklisting.
Blacklisting, my lord.
This, so far as the award of contract is concerned, that will be.
No, since they have scrapped, my lord, how can I insist this honorable court, my
So
lord?
that part of the thing.
Yes, my lord, they have scrapped it, my lord. They try to
Blacklisting.
float the tender.
Dr. Mojiga, you could have easily recalled it. You see, it would not have brought any consequence to you. But then,
My lord, just this morning I spoke to them, my lord. My lord, their concern, if that can be addressed somehow, my lord, is that if we recall that, my lord, because that is the sole basis on the basis of which we have terminated the contract, my lord. My lord, husband and wife, without disclosing that, my lord, they participated in the tender. Rules require, my lord, that they have to sign an integrity pact disclosing all these things, my lord, which they did not do. And this we came to know only when another tenderer, my lord, who was not successful, filed a complaint, my lord. So our only concern is, my lord, that this is the whole basis goes, my lord. The lordship is correct, because now it remains on, because here what happened, my lord, when the contract was given to him, as per rules, we paid him advance money, my lord. 20%, 30%. And so now we want recovery of that. And for that, we have filed a civil suit, my lord. He is saying that he has done some work and he wants to also file a civil suit for compensation, my lord. So that civil court will decide, my lord, our claim and their claim, my lord. We have no problem in that, my lord. The only bone of contention now is blacklisting, my lord.
Against that amount that we have withdrawn, my lord, we have also given a security deposit and is with them, my lord. They are,
now what ground you are challenged that blacklisting part? What are the main primary ground?
my lord, the primary ground is this, my lord.
Well, as you said that they do not have the power to blacklist you
Yes,
for.
But here,
Ever,
the law doesn't permit them, or there is no such statute which bar the husband and wife to participate in the tender process. Now, a tender process which was floated by them, my lord, is an online tender process. I cannot add anything, I cannot subtract anything, my lord. Whatever there is the requirement, I have filled it up. And if there was an additional requirement, my lord, they should have informed us. They have not contemplated anything in the form.
No, what required is that you made a declaration to these things.
Yes, we have made a
There is no
declaration.
bar for you to participate.
Yes,
But then you,
and we made a declaration. We made a declaration because the identity of the two different farms, my lord, are entirely different, my lord. Neither my CA or her CA is working for the same farm. It's two different farms, two different identities.
that is understandable. You see, different farms will always be different.
My lord.
You see, but then whether the owners are related or not, that is the question.
No, the owners are related, but whether they have any corporate interests on the farm.
That who will go and how it is to be determined.
That is what, my lord, they should have determined it. How they can say, my lord, there is.
Where is the law which basically
My lord, we kindly see.
required that a disclosure should be made? Disclosure should be made. Where is that provision?
My lord, may kindly see page 29. Page 28 or 29? And this is not the first time that I have participated, my lord. They are very much aware, my lord. We are husband and wife. It's not that this is the first time that both the firms has participated in the tender process, my lord.
All along you were in good book, now no more.
Probably I'm not in a good book of my friend. Well, let me kindly see. Clause 3.
Page 29.
29, my lord. Para 5, my lord, if my lord kindly see. Conflict of interest. Participation by a bidding firm or any of its affiliates that are either involved in the consultant contract to which this procurement is linked, or if they are part of more than one bid in the procurement, or if the bidding firm or their personnel have relationship or financial or business transaction with any official or procurement entities which are directly or indirectly related to the tender or execution process of contract, or improper use of information obtained by the prospective bidders from the procuring entities which are intent to gain unfair advantage in the procurement process or for personal gain, my lord. So these, under this, my lord, they are now only thing that they are pointing out is the relationship.
Their personal have relationship. That has been specifically mentioned.
Yes.
Yes.
So in our farm, my lord, there is no relationship. On what?
Personal. What about the personal?
Personal
Their personal have relationship.
Yes, personal in connection with business, in financial or business transaction, my lord. And my lord, now, if my lord, I take my lord to two judgments, which my lord is not binding, but they are the appropriate authorities, my lord, or appropriate forum which they have decided. Like my lord,
Can this decision be appealed? Any forum to appeal this thing departmentally?
I don't think, my lord.
So that is the final thing.
My lord.
Once the department
not
takes
taken that
action,
plea,
it cannot be
There is no alternative remedy. We have not
assailed anymore departmentally. Now this is a condition. This is a part of what? This.
tender, my lord, is a part of tender.
Acha.
Now, if my lord kindly look into a judgment which is passed by an appropriate forum.
Appropriate forum.
Yes, my lord. These sort of matters are decided by the Competition Commission of India, my lord. If my lord may kindly see.
So for you there is no scope for going
No,
to
for me, there's
Competition
no-
Commission of India.
No, my lord, there is no such scope, my lord. My lord, may kindly see para 17, my lord. What are the material which was before the authority who has debarred me, my lord? Before they decide, my lord.
How far this is binding on the
This
authorities?
is not binding on this code, my lord.
Not this court. I'm talking about the authorities. Does it bind them?
Yes, my lord. These are binding, my lord.
Now,
These are
if
binding.
that is binding, then that should. Dr. Mojika, is it binding on you?
My lord, Competition Commission is something like quasi-judicial authority under the Competition Act. My lord. Now, Competition Act, if we, Competition Act.
My lord, just have a look on para 17 only, my lord. That might.
One minute. 1 minute.
But my lord, Section 7 talks about establishment of commission, my lord.
Yes, 1 minute. So this is for the purpose of eliminating monopoly.
my lord.
Section 7.
Section 7 is the constitution, my lord. And the powers, duties start from section 18, my lord.
No. It's okay. And however, you see the decision of the commission. To what extent is binding on the department?
On the department, my lord.
Or what? You see, if there is a commission, definitely it has certain purposes, isn't it? And it will decide matter. The decision of that authority would be binding on which authority? Otherwise, what is the
But
use
it-
of enacting
no,
an
in-
act and creating some?
In my humble submission, my lord, the orders will be binding, my lord. Because Competition Commission is there, my lord. It has been given adjudicatory power, quasi-judicial, my lord. Then there's an appellate commission, my lord, that your lordship will see at page.
That is
Competition,
okay, that is all right. But then how far this decision should be binding on the
my lord,
government establishment?
my lord, orders will be
To what
binding.
extent? Mr. Day?
Well, it is binding, my lord.
On
It's
what-
like,
by-
seem like cat, my lord.
Now, that is where do we get it? Where is the indication?
Well, in this judgment, there is no such indication, my lord. If my lords want, my lord, I can come back tomorrow, my
That will
lord.
be core issue, say, supposing. If you can show it is binding, then definitely we can say that this
Well,
is.
I will come back
Up to
tomorrow,
your
my lord.
paragraph 17. Just let us just. What is para 17 of that?
My lord, may kindly see.
Yes.
There are 17, my lord.
My lord, to answer that query, my lord, section 42, my lord, talks about how the orders are. Section 42 of that, my lord.
These are certain points you have to enlighten the court.
But this is a new law for me also, my lord. The first time we're dealing
This
with
is
this.
2002 enactment, so definitely
we
it is
don't
new
have any
for
matters here, my
all
lord.
of us probably.
Because I think one of the few matters concerning
Referring to section?
section 42, my lord.
Yes, contravention of orders commission.
The Commission may cause an inquiry to be made into compliance of its orders or directions made in the exercise of its powers under the Act. If any person without reasonable cause fails to comply with the orders and directions of the Commission issued under so and so, he shall be punishable with fine which may extend to rupees 1 lakh for each day during which non-compliance occurs, subject to a maximum of rupees 10 crore, as Commission may determine. Then section 42A, my lord, compensation in case of contravention of orders of Commission.
That is okay, but then who will be that person? If any person means which person? That means the direction has to be specific.
My lord, Commission, even if you go by this order, my lord, they decide any matter by hearing both the parties. The councils appear, my lord.
So how those parties are presented before them?
But one person files a complaint, my lord. It is something like consumer court,
So say supposing
my lord.
that this problem, the dispute which
My lord.
the petitioner is right now, he could have brought it to this thing, that commission. This would have fallen under their jurisdiction.
Well, here, my lord, what happened? The private parties are doing the violation of Competition Act, my lord, husband and wife. Now we are the department. We discovered, my lord. That question, my lord, I will not be able to.
Now, whether this under the Competition Act, the commission will be entitled to take suo motu cognizance of a thing, or there has to be a complaint put.
There has to be a complaint, probably. My lord, may kindly see para 17.
Do not
It's
say
Ved
probably-
Prakash Tripati versus.
Do not say probably, Mr. Dey.
My lord, that is what I said that I will come back tomorrow, my lord. I will address in this point.
No, because say supposing now you are basically relying on a decision by the.
My lord, section 19, my lord, it talks about that, my lord. Inquiry into certain agreements and dominant position of enterprises. The commission may inquire into alleged contravention of the provisions contained in so and so, either on its own motion or on receipt of any information in such manner and accompanied by such fee as may be determined by the regulations from any person, consumer, or their association or trade associations. Section 19, my lord.
Yes.
So it is threefold. my
A
lord.
reference made to it by central government or state government or a statutory authority.
This is with regard to all those anti-competitive agreements and all those things.
But this is something like cement companies, they join together and manipulate the market, my lord. Or even liquor companies.
The basic purpose is to eliminate monopoly.
So
The
that
control should not be vested within few percentages, like should not be vested in a group. That is what. But then, till now, Mr. They have not clear to the court. See, like that part.
My lord, I couldn't follow. I couldn't follow, my lord.
That part,
Whether it is
the act and the decisions.
then, my lord, I will come back tomorrow, my lord. I will address in this point, my lord, because the cases, the facts are very clear, my lord. Now, why they have debarred me. Now, whether this judgment is applicable or not, my lord. On that point, I will address tomorrow, my lord.
Whether you see, like whatever proposition laid herein would bind them or not. That is the matter.
That is what, my lord. Just give me 12 hours, my lord. I will come back tomorrow, my lord. Tomorrow is not tomorrow, my lord. This is a long pending case, my lord, and he is hanging, my lord. Neither this side, neither that side, my lord. Let us finish him off. If you want to get finished, let him go.
Before what your paragraph 17 say? Let us see whether how much relevant it is.
It is further observed that as per the past decisional practice of the such allegation and incident has been found to be insufficient to even prima facie establish contravention of the provision of section 3 of the Act.
Yes.
The Commission in so and so has held that mere community of directors or ownership of participating firms in itself is not sufficient to record any prima facie conclusion about bid rigging in the absence of any material indicated collusion among such bidders while participating in the impugned tender. Similarly, the circumstances of now, my lord, we can skip 2 lines and come further in.
No, let us read it. Let us read it.
My
Just,
lord,
Mr. Tejas.
similarly, circumstances that OP number 9 and OP number 2 are located in the same area, it in itself is of no consequences in the absence of other material established concerning behaviors. Further, in so and so, the Commission has held mere having a common business linkage between the OPs are projected by the informant cannot be the basis to suggest collusion in the bidding process. Moreover, there is no material on record to suggest that the OP has engaged in bidding, rotation, etc. Therefore, the allegation of supportive bid does not find favor with the Commission.
See, we are not going on that to that extent. Whether there is a collusion, no collusion, Union has not gone to that aspect. The simple thing is that there is a requirement posed,
My lord,
and that has been violated.
my lord.
Whether there was a collision between you
No, but that is their intention.
and the other, forget about, you see, why should we go into those things?
My lord.
You see, if you come to page 29, it stipulates certain condition,
My lord.
which is a requirement. Okay, so once you fail to perform it, you will be held liable. What is wrong in it?
No, my lord. Now,
I don't think they have to go beyond that to establish that there is a collision between you.
No, but-
there was a.
what is my contention is this, my lord. Whether the issue that they have raised before this honorable court at this point of time, this is not on oath, my lord. There is a mere submission. The affidavit was not even sworn, my lord. On what basis? What was their intention or what material was before them, my lord? To say that there is a conflict of interest, my lord. There should be some material before them, before declaring me that, I have not participated fairly and I have suppressed something, my lord. Now, whether those material were available before them at that point of time when they passed an order, they have not even filed an affidavit.
No, see, basically, this is a requirement, isn't it?
Yes, my lord.
This page 29.
Yes, my lord.
So you have to fulfill this requirement
Correct, my lord.
when you take part in tender.
Yes, my lord.
Now you have failed to do that.
My lord.
You have not enclosed any affidavit or any disclosure statement
My lord.
that you have relation with some other participating firm. Now it itself is a violation of the terms and condition.
No, but whether that requirement was required or not, my lord. Whether there was the requirement. My question is this. whether that requirement was there or not for me to fulfill that requirement.
Why it is not applicable to all the participants?
No, this is applicable to all the participants, my lord. But where is the requirement? Whether this stipulate me that
Requirement is to be put by them.
No.
They have put it. Then
No, what is my contention is this, my lord.
you want to say the purpose of putting this requirement?
No, not purpose of the putting the requirement. My humble submission will be this, my lord. If the wife and husband participate, whether I am supposed to disclose this, and if I am required to disclose, where I am supposed to disclose, whether in that online format there was anything for me to fill it up, that I have failed to fill it up. Because it's an online, my lord, I cannot insert anything. I'm repeating the same thing, my lord.
You want to say
Yes, my lord.
that basically there was no opportunity for you
Yes,
to
my lord.
make any disclosure with regard to this
Yes,
at the time when you participated.
yes, and I have also.
So, because the system which was provided at that point of time
Yes, my lord.
had no this thing.
Even now, my lord, even now, the system is the same, my lord. They have not changed the system. It is a standard form, like in standard form for our.
No, but the standard form it has to be filled up, isn't it?
It has to be filled up, and there should be a column for me to disclose that yes, so and so is my wife.
No, but then if it is standard form, it has to be filled up and it has to be submitted. So have you done this? No.
It has to be signed and submitted. Like for example, my lord, there is a disclosure that this, and I sign it.
Yes, one thing. See, if you read this, whether this clause makes them liable to make a declaration. It is only in case if they have relation with the procuring authorities.
Yes, my lord, exactly.
My lord, page 29, I think your lordship is page 29, my lord.
Yes, yes.
My lord, we are more on clause 3, my lord, not on clause 5, my lord. More than clause 5, we are on clause 3, my lord.
Clause 5 is not applicable in their case, basically.
Clause 3, what it says, my lord, anti-competitive practice.
Yes.
Any collusion, bid rigging or anti-competitive arrangement or any other practice coming under the purview of the Competition Act 2002 between two or more bidders with or without the knowledge of the procuring entity that may impair the transparency, fairness and the progress of the procurement process or to establish bid prices at artificial, non-competitive levels. Our case is, my lord, the husband and wife, they violated clause 3, my lord.
Of the Competition Act.
My lord. And that your lordship will see that how close their rates are, my lord.
So, Mr. Dev, 5 will definitely not be applicable to you.
Now, my lord, coming to 3, I will answer
That
to
is
3.
not at all, no question, because you do not have, see, it would only apply in case where you have a relation with the procurement,
Yes.
either an official,
Correct.
okay. So,
Exactly, my lord.
so this is not at all applicable to you,
It is not at all applicable. But they have invoked that in the imputed order.
is it?
Yes, and they have invoked
Is it?
Yes, my lord.
So why Mr.
They have not
Dr.
invoked three,
Modi
my
is
lord.
saying that?
Now, my lord, may kindly come to the impugned order. Now, page 51, if my lord may kindly come to page 51.
One of you can go. See, one of you can go. Yes.
My lord, may kindly see para 4, my lord.
Yes.
Now they are saying the post the award of the contract to so and so, it was reported by another bidder that so and so is the husband of so and so, owner proprietor of Messrs. GSG Associate, so and so, Kitting Road, so and so, so and so. Another bidder for the subject contract. Therefore, a query was raised from so and so, so and so. So and so submit his reply clarifying that this, the fact I have admitted, my lord. But and I have admitted, I have also mentioned, my lord, in that show cause. But the business of me and my wife are separate and we have no business transaction whatsoever. Now, my lord may kindly come to now my lord may skip 52, page 52. My lord may kindly come to page 53 directly. Para 5, my lord.
One, Mr. Day. Para 5.
Para 5.
Page 52.
Page 52. 53, my lord.
The small pair on the top, my lord.
On the top, yes.
Whereas in the above reply, see so and so owner of La Monte Enterprise has unvocably and uncertainly consented that the spouse relation with so and so, whereby the reported allegation against him stand self-verified as true.
That is so far as the relationship is concerned.
Yes, yes, my lord. Now, my lord, may kindly come to page 54, my lord.
Yes.
So, my lord, para 7.
Yes.
Now, they are saying here, my lord, that the conduct of so and so enterprise is willfully and knowingly suppressing the spouse relations with so and so.
Spousal relation is anyway. It's okay.
It's not relevant, my lord. It's not required.
Anyway, that is not the condition, not the constitutional tribunal, apparently.
And para 8, if my lord see para 8, in consideration of facts and circumstances, so and so, so and so. Now, there is no finding. My point was this, my lord. There was no finding of bid rigging, my lord.
So it means anti-competitive practice.
Yes.
There is no evidence of that.
There is no
Nothing,
evidence.
nothing.
Yes, my lord. If there was, my lord, they should have contemplated in this termination or blacklisting order, my lord.
And you see, it is not necessary just because you have a relationship,
Yes, my lord.
you will be entering into anti-competitive practice.
Yes.
There cannot be a presumption to that.
There cannot be presumption.
Just because you are there, your brother is there,
Yes.
there will be anti-competitive practice. That
Now,
cannot be presumption,
if
isn't
I
it?
can just point out one thing, my lord. Now, Mukesh and his brother, my lord, Anil Ambani, they are participating in many gas projects, even in Geo, my lord, telecom department. They are participating, my lord. They are not barred because they are brother.
No, there is no bar. You see, if they say, you see, now what is clear is that the clause 5 is not at all coming. You see, it's not attracted. So, what is the case is concerned?
Yes.
And just because there is a spousal relationship also, that also cannot cause any debarment.
Yes, yes.
Okay. If they say that they have basically invoked power under clause 3, that is anti-competitive practice, in such a case there has to be evidence of that.
Exactly.
Now what would constitute anti-competitive is any collusion, bid rigging,
Yes.
or anti-competitive. So what is bid rigging? Or any other practice coming under the purview of Competition Act 2020. That means section 3(1).
Yes, my lord.
Between two or more bidders, or without the knowledge of the procuring entity.
And now that is why, my lord, the judgment will come into play, my lord.
So now only we have to see that whether in the impugn order there are sufficient evidence of anti-competitive practice or not.
Yes. Correct, my lord.
Now according to you it is not there.
It is not there, my lord. Now it is for my learned senior friend to point out where it is mentioned. Second thing, my lord, what I was instructed, and on being instructed, my lord, I am submitting.
No, but then you said they have invoked this clause 5 in their impugn order. Where is that? Is there any specific invocation?
No, there is no such specific, my lord. They are hitting around the bush, my lord. Now, my lord, we kindly come to page 51. They have just quoted clause in the show cause. They have quoted only 3 and 5, my lord. But in the impugn order, my lord, they have quoted the law, but they are hitting around the bush. They are not direct or specific.
Now in the impugn order nothing has been. Where is the show cause notice?
It's on page. Show cause notice is on dated 17 March, my lord, page 44. My lord. 45, my lord, sorry, 45. This is the reply, my lord, I have given.
No, what is this notice by them?
42, my lord, page 42. Page 42, but if my lord may kindly come to page 43, my lord will see they have quoted clause 3 and 5.
One minute, just let us go by this. Yes, Mr. Dev, what you were trying to point out?
My lord, may kindly come to page 44, my lord. Before I come to 44, my lord may kindly see page 43.
Yes.
They have quoted, they have omitted everything, only they have quoted clause 3 and
Yes.
5. Now, my lord may
That
kindly
is the part of your affidavit. They have quoted the part of your affidavit, which you submitted.
Yes, my lord.
Yes.
Now, my lord may kindly see page 44.
Yes.
Whereas page 44, para 4, whereas the entire matter was placed before the Director
One
General.
second. Before the come to para 3. Now allegation is only that such and such is your wife.
Yes. Exactly. my lord.
Whereas post the award of the contract to your company, it was reported by another bidder that owner proprietor of your company, Sri Bhupinder Singh, is the husband of your see. So we can say, subject to
My lord.
before Dr. Mojika comes into picture. can we always interpret it like this way? You see, so far as the process of the settlement of contract is concerned, there is no suspicion, nothing. Suspicion came only after a person filed lawsuit,
Yes. Yes.
isn't it?
Yes.
So otherwise, the materials on record
Yes.
did not pinpoint that there is some anti-competitive practice.
Correct.
Now the allegation came more just because
A complete-
your relation with this.
Yes.
That is
Yes. Now, let me kindly come to page 40.
just see the paragraph 3 says
Yes.
it is reported by another so and so owner proprietor so and so particular Meghalaya is the husband of so and so.
Yes.
And see, Vivinder has confirmed by it so and so. They were rendering the before quoted certificate above as false, and now this is one thing. Anyway,
Now, let me kindly come to page 44, para 4.
yes.
However, the entire matter, whereas the entire matter was placed before the Director General of Assam Rifle, being the contract approving authority, and has, after due deliberation and consideration of the view that your company, owner / proprietor, by intentionally and knowingly suppress the fact of being the husband of so and so, has breached the terms of the subject contract agreement, necessitating show cause action as to why the award of the subject contract to not be terminated with the consequential action for recovery of the public fund released to your company by and under the authority of the Director General, Assam Rifle, for the contract, as also the blacklisting of the company deliberating its permanent for participating in any tender action for procurement of whatever nature within Assam Rifle. Now, my lord, what was considered for issuing this show cause notice? That I am the wife or husband
That
of
is the only basis.
that is the only basis, my lord. Now, my lord, they are hitting for clause 3. Now, if there was any material for clause 3, my lord,
Now, where is your reply to it?
it is in page 45.
Are you saying that the impugned order, basically, or the grounds taken there, basically it's a kind of enlargement of the allegation than what has been mentioned in the Shaukat notice?
Oh, my lord, I have.
Did you get the question of the court?
Yes. What they are saying is this, my lord. They was not in clause 3, my lord. They was in clause 5 initially.
Your
Now,
reply?
now they are in clause 3.
No, that was, anyway, it's all right. No problem. We'll take into consideration both. Yes.
Now, my lord, may kindly see page 47.
Yes. What is your reply?
My reply says, my lord,
Now, in Shauka's notice,
yes, my lord.
do they specifically say that you have entered into a collusion?
No, nothing, my lord. Otherwise, I have no case.
There is nothing of that thing,
Nothing.
except for mentioning that you are husband and wife,
Husband.
and you have failed to make a disclosure to that effect.
Yes.
Nothing of that sort.
Nothing of that sort.
Yes. Now your reply, where is that part that where you admitted that husband and wife?
Page 48, my lord. Oh, yes.
Yes. Where? Where is that?
My lord, may I have to see the first reply that I have given, my lord.
How many replies you have?
There was two reply, my lord. First, initially, they, to confirm, my lord, they have issued a notice that is on page.
What is that page 45?
Page 45, my lord, is the second reply, my lord. Okay, my lord, may kindly see page 45.
Your show cause notice is dated 17th March.
Yes, my lord.
17/3/2020.
The first show cause reply.
Now your reply at page 45 is at on which date? That is dated when?
This is on 24th, my lord. 24th, 5th, 2020.
24/5
Yes.
in the month of May.
Now,
This is your second reply.
yes. If my lord may kindly come to page 39, there is the first show cause notice which I issued to me.
How many show cause were there?
2, my lord.
It's not a so called.
It is a confirmation, they want to get it confirmed, my lord. So I have replied to it, my lord. It may not be taken to.
No, but then
If my lord may
there is
kindly-
first one is 39, page 39, is it? That is not a show cause notice, it's only confirmation.
It
Not
is a confirmation, my
it's a
lord.
letter of confirmation, is it?
Yes, this is a letter of confirmation, and then I have.
Wait, just a minute. But then it will have relevance here in your case. Definitely.
Seven days time was given to me to confirm, my lord.
2020. And then you reply to it.
On page 40, my lord. 2nd of March 2020. The first paragraph, para 1, my lord.
Yes.
I'm confirming. The fact that we are husband and wife is agreed upon, and we are living together with our children with all the given socialite norms, but the business of me and my wife are separate, and we have no business transaction whatsoever. Now, my lord, we can see para 5 also, my lord.
Yes, you have taken that thing.
Yes. Then they have issued me a show cause. Letter dated 17 March, around 20, and then I replied on 25th May 2020.
Yes, anything more?
My lord, page 48, if, my lord, I have specifically stated in the show cause reply with regard to the content of para 4 of the notice.
You are reading which paragraph?
Page 48, para 8, my lord.
Okay. The first paragraph.
Yes, first. I have stated conclusion arrival by by the Director General Assam Rifle based on the only fact of a matrimonial relationship to issue the show cause notice does not hold any water, as the entire show cause notice is absolutely silent as to how my relationship has breached the terms of the subject contract agreement or without specifying with the clause under Appendix L, my lord, is in violation for the issuance of the show cause notice, my lord.
Yes.
So this is my case, my lord, that whether the husband and wife can participate and whether the disclosure is required, my lord. Subject to my lord, senior what he reply, I will counter to that.
Do you require to hear you, Mr. Dr. Mazia?
Only one or two points, my lord. My lord, as far as the sequence of facts, my lord, I do not remember whether Lordship noted down, because I placed the records, my lord, with flags, if Lordship recollects that.
Notice, yes, record was called for and it was placed. And
But
then
the
they
facts of
also,
the entire story will come
see, right now,
when tender was issued
so
and what
far as
happened.
the tender things are concerned, we may not go into all those things because
My lord, little bit it is relevant, my lord. Why, my lord? Only one thing I wanted to point out to your lordship, my lord. If I can just place few flags, my lord, from here.
yes. One. Earlier, was any part of the record was submitted to the court?
No, my lordship gave it back to me because on the last hearing, my lord, because the issue boiled down to a very small point, my lord.
Yes, yes.
And I was instructed if you can recall the blacklisting, then hearing may not be required, my lord.
This is the brief of the case, my lord. I have given this.
This is prepared by you.
Yeah, this is prepared by me.
List of dates.
Yes, my lord. Here everything is mentioned when the complaint was lodged and all this. Because initially when I filed my petition, my lord, certain information was not there with me. Subsequently, I have procured this information and then I'm placing, my lord.
When this was scrapped, this Dr. Mojiga, when it was scrapped?
My lord, we filed an affidavit, my lord, for that.
Grab was done, my lord. September 23, my lord. September 23. August 2023, my lord. They have filed an affidavit.
Before this court?
Yes, they have filed an one-page affidavit, my lord.
Achha, it is there in the record. You say
Yes,
it is a
yes,
part of record.
Yes, yes, yes. Annexure A. And this affidavit was sworn on September, my lord. September 2023.
Yes, that is the order, isn't it? Oh, that is the 29th August 2020.
Yes, yes, my lord. They have informed. They have taken a decision to cancel the project, my lord. So, my lord, here I will just want to submit 2 points, my lord. They have scrapped when the matter is pending before His Honorable Court. Whether leave was taken or not, my lord, because that was under challenge. Second thing, my lord, I have paid 1 crore rupees for GST, my lord. Now, there is a lapse of 2 years, my lord. I will not get back that GST also, my lord. 1 crore. It's not a small amount, my lord. 1 crore I have paid GST. And certain materials are still lying with the respondents, my lord. They are not even releasing.
This will be taken care in that civil suit.
So that liberty has to be given because now,
No, that will always be there with you.
no, my lord, because there is a delay. That is only my apprehension. Because there is a delay. Because it will be a money suit to recover the money, my lord. So, my lord, they point.
You say there is a delay, there is a provision of condoning it.
Yes, there is a provision, my lord.
This court will not pass any order condoning that. You know that. That jurisdiction is not there.
The jurisdiction is not there, but
And your cause of action, basically, it depends upon, you see, like this court will definitely not give you a legal advice. That is for you to formulate.
my lord,
But then it depends upon which way you formulate your cause of action.
my lord.
But there is another aspect, my lord. Termination is 2020, my lord, May 2020. COVID limitation extension was there, my lord. They'll get.
That is always there. That is always there. So that liberty.
My learned friend submission may be recorded, my lord.
That is Supreme Court has said.
Supreme Court
I know that.
This I'm giving free advice. my lord.
this court has not come to any decision till now.
My lord.
So that will depend upon.
There are 2 files, my lord. I have been instructed to inform this honorable court or to pray before this honorable court, my lord. May kindly take care of both the files, my lord. As per the last hearing, which was a length hearing, my lord, before the other court, my lord, before Honorable Justice H.S. Thank you, my lord. Then the file was called, my lord, and the file was examined, even by the petitioners, also petitioner counsel, my lord. And we find out, my lord, in the file, my lord, there was an CVC, Central Vigilance Committee. They have given a clean sheet that husband and wife can participate. And MHA has cleared that file also, my lord. That, my lord, may kindly have a look, my lord, on this.
So that then we have to call for that.
Is there, my lord? Is there?
Records are there.
Records are there, my lord.
Can we have an extract? Why to have such a this thing? Give us the extract of that part which Mr. Day is pointing out.
Yes. My junior will.
I don't know which document. I can show it to him, my lord. Whatever he says,
See, I've been instructed.
Can you find it out?
Yes, my lord.
Please find it out. Then we'll tell them to give us extract of that.
Yes. Vigilance file.
Dr. Mojika will not help you in that.
Definitely not, my lord.
It's so bulky, my lord. This record.
Yes. It's very bulky, isn't it?
File 2, file 3.
Vigilance file. Give me the vigilance file only.
Check which one it's not mentioned vigilance file separately.
Yes, doctor. Come to your submissions now. What do you want to say?
See all the 3 files.
I'll just give few facts, my lord. 4 or 5 dates, my lord.
Yes.
My lord, the tender was issued on 26/9/2018, my lord.
Yes. Mr. Day has supplied a list of dates. I think if you refer from there, that will be easier.
But that covers that.
The first date is 26/9/2019.
At serial number 4, my lord. No. Yes.
I haven't given.
Yes.
The first page.
My lord.
Yes.
So, my lord, tender was issued on 26/9/18. Now, 4 bidders, my lord, that I think will not be there in Mr. Day's.
Anyway, just tell us. Okay.
My lord, 4 tenders participated, my lord. One is Paramhans. Lords, you would like to note down, or I can give a synopsis by today itself. I can submit, my lord.
Achha. All right.
4 participants with the my lord. Paramhans 1, Lotus 1, and husband and wife there 2, my lord. Total 4 participated in the bid, my lord.
The husband and wife had different name, isn't it?
Different entities, my lord.
When you give us
Adding me.
My lord, husband is Lamonte, my lord, and wife is GSG Associates.
Okay, anyway, if you give us a writing thing, that will be
My lord.
we see.
My lord.
Okay, indeed.
Now, my lord, when technical evaluation was done, Lotus was disqualified in the technical evaluation, my lord. So only 3 were left, my lord. All 3 of them, my lord, were asked to give a presentation, my lord, by the Assam Rifle, that what kind of, because this is a
Firing range.
simulated, some high-tech training equipments were there, my lord. So they were required to give a presentation with a project report. All 3 of them they brought, my lord. Paramhans was disqualified at that stage, my lord. First, Lotus was disqualified, my lord. Second, and Paramhans. Now, Paramhans is the person who later on filed the complaint, my lord. Paramhans, when they were disqualified, my lord, and so only there 2 were left, my lord, GSG Associates and Lamonte. Their financial bids were opened, my lord. And Lordship, what is very crucial, my lord, the bids, my lord, are so close, my lord. Lamonte's bid was 18,79,000, 18 crore 79,80,000, my lord. 18 crore 80 lakh 79, and GSG Associate, that is wife's firm, 18 crore 90 lakh rupees, my lord. So total difference of only 11 lakh rupees in the tender of 18 crore
This is a
rupees.
close contest. What presumption can be drawn from there?
But the presumption can be drawn, my lord,
Go
that
to- see,
they had access
Go
to
to
each
any
other.
market anywhere. If you see there are series of shops selling identical products, price variation will not be that much. Of course, it would be known to think open pricing, open thing. But then here also it is something like that. Business people taking part.
My lord, I'll refer to one Supreme Court decision, my lord, where it
that
says
is one of the aspects.
where it says, my lord, that whether there was entity
That is the one basis of your suspicion.
suspicion. But I must admit, my lord, that is not reflected in the impugned order.
That if it
My lord.
is not reflected
It's
in
not
impugned order,
reflected as such, my lord.
it is
that
not
their bids are very
reflected
close.
in your show cause notitions.
It is not reflected there also. My
So
lord.
if that be the thing, I do not know how do you expect this court to go into all those things.
My lord, I'll just,
See, we know as a council you will make out many more grounds.
my lord.
But then those grounds were not there when your officers took.
My lord, the impugned order has almost gone there, my lord. But
We can understand Dr. Mojika. You can justify this order
my lord,
by bringing your own grounds, of course.
my lord.
But then this
Yes,
may not basically, you see, a substitute of the order which your department has.
but almost as order has almost gone there, my lord. But they have not quoted that 18 crore 90 lakh or 18 crore 80 lakh. Only
That is a fatal mistake.
So that
At least for this court, you do not expect this court to travel beyond these things. Will be confining your case to your show cause notice, meaning therewise how much opportunity you give them to reply,
my lord,
and what you have held in your impugned order.
my lord,
And that would be the basis for determining this case. Nothing more than that.
my lord. So, my lord, so work was awarded to the red petitioner, my lord. Then Paramhans submitted a complaint, my lord. Who was disqualified at the second stage, my lord. Now, I'll give a list of dates, my lord, indicating all this. My lord, first complaint when he filed, he did not mention anything about this fact that they are husband and wife or their baby. He simply said, my lord, that the prices are very high as compared to market price.
This complainant.
In the complaint, my lord. And he has said that the topmost manufacturer of this kind of equipment, my lord, have been disqualified. Lotus and Paramhans are very renowned companies, and it has been given to average companies who maybe do not have experience or not a market leader in this. So those are the complaints. I'll point out to that complaint also, my lord.
This complaint is a part of your.
It is in the record, my lord. It is not.
In your affidavit, it is not.
It is not there, my lord.
Now, if you argue on something which is not a part of record, will it be proper for this court to take these things? You may have many things in records. How they will get the opportunity to refute it?
Well, actually, what happened, my lord? This matter was at that time.
Dr. Mojika, I see. It is not that you understand. We know maybe it is handled by somebody else or something like that.
My lord.
We can understand that. That is why this court at the beginning said the deficiency of your own you can cover it up.
My lord, for the present purpose, my lord, it may not be necessary since it is not on record. If your lordship permits me, I'll not go into.
No, but then
complaint.
if you are going into all those aspects
My lord.
about the repetition of farm, elimination of repeated farm, awarding of
My lord,
contract to
So, my
and
lord,
not so known
for the
farm.
time being, I'll omit that my submission, my lord. But now, my lord, in the second complaint, he mentioned that they are husband and wife, my lord, and that was the complaint dated 13/3/19, my lord. The Paramans informed that they are husband and wife.
Complaint is not here.
Complaint is not on record, my lord. Now, after this complaint was received, my lord, then we issued the so-called notice. That is on record, my lord. Lordship will find.
That is, Mr. Day has pointed out.
Mr.
Mr.
Day has pointed out
his
that
reply.
to confirm that whether you are husband wife or not. First, that was
yes.
so he confirmed that she's my wife, and thereafter a detailed so-called notice was issued, my lord. Now there are 2 or 3 aspects, my lord. The lordship has seen the appendix L, my lord, clause 3 and clause 5. Our case is more on clause 3, my lord, where prices are manipulated by 2 entities, my lord. Anti-competitive practices, my lord. Now, in my short affidavit that was filed, my lord, this was filed sometime in June 2020, my lord. June 2020, my lord. This is, my lord, a preliminary objection for a non.
There is affidavit. Yes, 19 June.
My lord. Okay, 19 June. Yes, preliminary objection.
This comes as an additional affidavit.
But one preliminary objection is written, my lord.
Preliminary objection is the 26th June, my lord.
This is the 1906 one. Is
There
there?
is 2 affidavit filed by them. One is the preliminary objection and the other one is
there?
additional affidavit.
1906.
No, 26th June.
26 June, nothing is there. It is 1906 and then 1909.
It must be 1906, my lord. It's by Lieutenant Colonel Aditya Sukla, my lord, the deponent, my lord.
Yes, but then it comes as an additional affidavit filed for.
This is a different one. This is the preliminary affidavit is there, my lord. They have served as a copy also. And it has been registered on 26, my lord.
26.
26. It has been,
Nothing is 26.
no, probably it is the miscase record, my lord. It's in a miscase.
Miss case number 104. Additional affidavit.
Yes, it's a miscase.
Well, in this affidavit, my lord, page 22, my lord.
Miscase is about what?
Miscase
For stay, I think.
For the stay.
Any order passed in that miscase? No.
The criminal case was
Stayed.
stayed, my lord.
Yes.
Page 22, my lord.
No, that is a shock cause in the miscase.
Yes, my lord.
You are not referred to your affidavit of opposition in the case,
They have not filed even.
which is more elaborate. Will it not be appropriate to refer to the affidavit of opposition, Dr. Majika?
What is the additional affidavit?
They have not filed the additional affidavit. Sorry, my lord. Affidavit in opposition. They have not filed. They have filed 2 things, my lord. One is the preliminary objection in the my miscase, and another one is the additional affidavit. Dated 1996. 2000.
Yes, yes.
These are true.
This additional affidavit.
This is the additional affidavit.
Yes.
Is there any prayer by you to treat this thing preliminary objection as a position?
But
See, we do not know. You see, now we have a kind of practice here. I do not know.
my lord, in this affidavit, I'm only pointing out where is the rules, my lord. I'm only pointing out the rules, my lord.
Yes. Where is it?
Page 22, my lord, this is general financial rules. My lord, rule 175.
Page 22.
22.
Yes.
Rules 175, my lord, on the left hand side.
Code of integrity.
Code of integrity, my lord.
Yes. Okay. What does it say?
My lord, it says no official of a procuring entity or a bidder shall act in contravention of the codes, which includes prohibition of, my lord, A, B, C, D. I am on clause 2, my lord, disclosure of conflict of interest.
You'd have to go to the next page, isn't it?
No, on the same page, my lord, small Roman 2, my lord. On the next column, my lord,
Acha, disclosure of conflict of interest.
disclosure of conflict of interest. Then, my lord, on the next page,
Now, you yourself, your conflict of interest, you are saying that your paragraph 5 is not that relevant. Paragraph 3 is more relevant.
my lord, what I'm trying to say, my lord, I'll point out 3 rules, my lord, here in this affidavit. First is 175(1), my lord, disclosure of conflict of interest.
Just give me 1 minute, Dr. Majika. I'll just make a note of this. Yes.
So rule 175 GFR, my lord.
Yes.
Then page 23, my lord.
This will be reference to rule 75 1
Rule 175,
1 then subclause 2
subclause my lord.
Roman 2.
My lord.
This is to be noted that way, isn't it?
My lord. Then, my lord, on the next page, my lord,
Yes.
this I pointed on the, my lord, only to show, my lord, to be very fair, my lord, the debarment can only be for 2 years, my lord.
Yes.
At the bottom, my lord, debarment from bidding rule 151.
Yes.
A bidder shall be debarred if he has been convicted for an offence under Prevention of Act, Indian Penal Code, my lord. Subclause 2, a bidder debarred under subsection any of the bidders shall be not relevant one. Clause 3, my lord.
Yes.
A procuring entity may debar a bidder or any of its successors from participating in any procurement process undertaken by it for a period not exceeding 2 years if it is determines that the bidder has breached the code of integrity.
No, that goes against you then.
My lord. So maximum is permissible is 2 years.
So that order,
My lord, to that extent, in my humble
it is
may
illegal.
not be correct, my lord.
He is very fair. See, he is pointing it out. He's a fair man.
Yes, my lord. And I have also pointed out before my learned senior pointed out.
Definitely. that is your case. Mr.
Yes, my lord. Yes.
That is a weapon for you to
Yes.
attack the others. But then,
My lord, page 26, my lord. This is a part of, there is a manual of procurement of goods, my lord. This is which applies to, these are executive instructions, my lord.
no, there has to, if you go by these rules, there has to be a finding by you that the bidder has breached the code of integrity.
My lord.
Yes.
My lord, page
Next, you
26.
are pointing out to
Clause 9, my lord. It's page 26, my lord. It's the last page of the affidavit.
yes.
Clause 9, my lord,
Conflict of interest among bidders.
among bidders. May I just read few lines, my lord. A bidder shall not have conflict of interest with other bidders. Such conflict of interest can lead to anti-competitive practice to the detriment of procuring entity's interest. The bidder found to have a conflict of interest shall be disqualified. A bidder may be considered to have conflict of interest with one or more parties in the bidding process if, my lord, A, B, C, we can skip, my lord. D, we are on D, my lord. If they have relationship with each other, directly or through common third parties, that puts them in a position to have access to information about or influence on the bid of another bidder.
Yes. So, do you mean to say that once the persons are within the close relationship, that will be a presumption? D will be presumed automatically.
My lord, that puts them in a position to have access to information of the other, my lord.
No, that
My lord, if
what
husband
is the
wife-
basis on which you would say? You have to come to a finding
My lord,
that they are,
so closely related or
you know,
They are-
situated in a position to have access to information.
each
about
other's
it.
information, my lord.
Now, you would,
So, my lord,
that
so-
means your contention would be that
My lord.
if somebody is having close relationship and residing under one roof, this will come as automatic presumption.
Not automatic, my lord. They have relationship with each other directly or through common third parties that puts them in a position to have access to information about or influence on the bid of another bidder.
Now, here it is common, even third party is not coming. They are more closer than that. They have direct these things, and there is an admission that they are residing together with their children. That is what their admission. Now, the court is putting you a question that whether that fact would be enough to presume that there is a conflict of interest as provided in clause D.
My lord, under clause 9D, my lord, in my humble submission,
So, in such a case, say supposing once a person admits that there exists a relationship, why do you hold this thing, shock cause and all? That admission should be good enough to debar them.
that puts them in a position, my lord. My lord, in fact, the order is in that direction only, but only because you are husband and wife. That is enough. We do not need any further evidence, my lord. That is why they have not discussed anything in the order.
Then why that shock cause and why that this thing?
Well, so goes, my lord, because debarment says that debarment cannot be done without.
So that
So
becomes a
without shock
formal
cause.
practice.
My lord, but the previous
Now,
order,
which part will be just trying to, this court is trying to get from you,
my lord.
which part will be more relevant? The first part, where he confirms to your query that they are husband and wife, or the second part, which comes consequent to this thing, shock cause notice. Now, first part requires no finding because admission by them.
My lord.
We are husband and wife. Now, that part would be good enough. That will make the second part infractuous.
My lord, in the impugned order, my lord, I'll just point out few lines from the impugned order. What the
In such a case, we
what the
say,
authority said, my
irrespective of
lord.
whatever you say, whether your impugned order is legally tenable or not, the admission is good enough to sustain the punishment, and it is sustained. Can a court record that sort of verdict?
My lord, to submit on that will be a little difficult on my part also, my lord, because rules are speaking something different, my lord. Whereas the appendix L, that was there, clause 3 and clause 5 there, their wording is slightly different, my lord.
Now, you see, if you are, by your own submission, that you are not more on clause 5 of that page 29,
More on clause 3, my lord.
more on clause 3, then this 9
Not that,
also, that
the-
9
the-
also
is,
may not
my
have that
lord,
much relevance.
Why I said, my lord, more on clause 3, my lord, meaning that clause 5 also is there, my lord, but clause 3 is more prominent, my lord, in our case. Conflict of interest. Anti-competitive, my lord.
No, if we go by the interpretation what you would like to give to clause D, then in every case where two members of a family are in business, we have to presume that there exists collusion.
But in my humble submission, this is qualified, my lord, that puts them in a position. Now, Anil Ambani and Mukesh Ambani are not even talking to each other, my lord. They are best enemies, my lord, now.
So your D is becoming imperative.
My lord, that is not putting them in a position to. My lord.
Anyway,
Personal knowledge I don't have, my lord, that whether they are talking or not. I don't have that access of information whether they are talking or not. But I know, my lord, the elder brother has rescued the younger brother when he was in problem.
Anyway, we are not going to this thing. We will not decide anything by taking their instance. What we are much on to think is that whether just this fee, like this existence of relation, would be good enough to say that there is a conflict of interest and there is unethical practice.
Yes.
That is what.
Yes. And whether that has been contemplated.
In my humble submission, reading all together, my lord, even the decisions and other things, my lord, the fair conclusion, my lord, in my humble submission will be simply because husband or wife or their brother and sister may not be, my lord, disqualifying factor, always, my lord. But if they are in a position that they can influence each other's, my lord. That is
No, that is one arena. That is one arena. How you determine it? I am known to you. I may have I may influence you.
Because some decisions, maybe there, my lord, for example, big groups, my lord, even in India, maybe to name Tata, my lord, there are many companies, there are directors in many firms. But Mr. Tata will not go, maybe his two entities are bidding in the same process, my lord.
That is what the decision furnished by
My lord.
Day,
My lord.
Mr. Day says the same thing.
My lord.
There cannot be a presumption that the one person he holds post of director into
One common director is there.
there is a collusion between them. We cannot.
Because that director may not
It means your standard of proof has to be something beyond that.
My lord.
Now you have to go beyond the relationship.
One step further, that
Yes.
you're in a position to have access or influence others. No, husband can tell wife, no, you don't bid this much, you bid this much.
Yes. So
It should be that.
your impugn order will be tested on that touchstone.
But I
Some has the information that husband and wife they are talking.
my lord, though impugn order doesn't say, my lord, but the inference, because the bid price are so close, my lord.
Now, if you talk about price and all, do you mention it in the show notice?
My lord, I have to admit, my lord, it is
If that,
neither
that
mentioned in the
becomes a
focus.
reason. So you can understand in our system, until and unless you put forward a situation before him, you cannot held liable that person, cannot hold that person liable for that. At least you should give him a chance to explain that. That you have not done. You see, precisely probably when in the earlier round of these things, the suggestion was quote from that if you can, you also will recall that one. If you see, but then since you are not doing it, we have to go into all those things. Perhaps,
My lord, like what I understand, my lord, at this stage, my lord, most of his prayers have become infructuous, my lord. Except that blacklisting.
blacklisting has
Only
a
blacklisting, my lord.
has an adverse effect.
So lordship is entering into the merit only to determine whether blacklisting was correct or not.
Definitely, we are confining this thing. This court will not go beyond this.
So my lord, that is, I have only one or two Supreme Court decisions which only say, my lord, that there cannot be any direct evidence of collusion, my lord. It can only through
Does it this whether those decisions say what should be the minimum standard of evidence?
It doesn't say, my lord. It only says, my lord, that there cannot be direct evidence. It has to be drawn by inference only.
No.
But again, my problem is that
are we not in some area? See, like it is not something that you see just by virtue of the relation, admission of the relation, that there is a presumption against them.
and the price is also so close.
And then again, you say that yes, we can understand that there cannot be conclusive evidence in this kind of things. But then there must be something. Now, if you say that the prices are so close to each other, then there has to be, there it is in your finding, in your Shoko's notice. Nowhere it is
That
there.
is that is not there, my lord. Otherwise, it was a,
Closeness of price is not there.
my lord, it is not there. My lord, the only finding, my lord, what in the impugned order, my lord. Mr. Day has not read that part, my lord. But of course, what your lordship said, it is not there, my lord. In clear terms, it is not there. Neither
There
it was mentioned in the
there may
Shoko's.
be one, two parts Mr. Day has not read.
My friend also has need to perform, my lord, for his department. So that part I have omitted. I have not read. which is not relevant for me, my lord. I have not pointed out before
It's
this.
all right. It's all right. It's you are the best judge. You are the best judge of your case. You see, like what should be pointed out and all those things. There's no issue on that. What contention you have taken in affidavit of opposition with regard to blacklisting? You have anything more to point out from the rules?
No, my lord.
Just then let us come to your affidavit of opposition.
There is no affidavit in opposition, my lord.
Well, I'll only read from the writ petition, my lord, the impugned order, few lines, my lord. The impugned order,
You have not filed any affidavit.
there's no affidavit, my lord. The matter is proceeded only on the basis of preliminary.
What about your additional affidavit or something which you have? Now, if you have not filed an affidavit, then how an additional affidavit comes?
But additional affidavit is only to the effect, my lord.
No, without the main affidavit, how additional affidavit comes? This is something not understood, you see.
This one, the affidavit is- Not this. This was the additional should not have.
This is the additional.
No. The other affidavit. Oh, June.
Now, this additional affidavit will not have any relevancy at this stage now. See, because that is probably in relation to encashment of bank guarantee and all those things by them.
My lord.
So, this further the civil suit is pending, see, like this will be.
And the other affidavit only that we have abandoned the project, my lord, only to that effect. my lord. The other affidavit only
Then,
to
so far as your rebuttal with regard to the contention
that. There is
of
not on
blacklisting, how to gather it from your affidavit? Should have been an affidavit in opposition. Without that, you decided to contest the case. Is it not something unusual?
That's true, my lord. That was my mistake only. The preliminary objection, because some pleadings were there, I thought this is the main affidavit, my lord. Today I noticed that this is filed in this case, not in the main case. This also.
This clause 9 which you have referred in rules, it is a part of rule 157, isn't it? Is it rule 157 clause 9?
My lord, it starts from page 25, my lord. Manual of Procurement of Goods, 5.1.4, my lord.
No, but then it's a part of rule.
5.1.
In earlier pages you find that rules are there quoted. Rule 155, 156, 1.
But here it will be a clause, my lord. These are not rules. Yeah. My lord, page 25 will also kindly see, my lord.
So this is manual for.
Procurement of goods. Issued by the Minister of Finance.
It is recorded and then how it is recorded? It used to be clause 1, clause 9 of what?
Clause 9 of, my lord, previous page, lordship sees, my lord. Page 25.
Yes.
This is the main clause, my lord, 5.1.4,
Information to bidders.
my lord. Then here it 1, 2, 3, small Roman 1 goes, my lord.
No, that is okay, but then this is. See, the earlier part where rules are there, this is the General Financial Rules 2017.
My lord.
Yes. Now this is a part of what? Manual for. Now if you say manual,
My lord.
manual may consist of many things, not one subject.
This manual is very thick, my lord. It deals with a different
That is
aspect.
That is why this court wants specific information. This is of what? This is from any instruction, guidelines.
Manual is not
As you understand, if you refer something as a manual, that would mean many
like
things.
Assam Police manual, my lord. Or any manual.
You say manual of a criminal law manual. It will consist CRPC, IPC, Evidence Act. So while you refer to particular things. Okay. Here also it's referred as manual. But then these clauses will be part of some particular instructions or guideline. Now that is what this court wants to
No,
know.
my lord. My lord, Ministry of Finance, Government of India has issued two manual, my lord, dealing with tender, my lord. One is for manual for procurement of goods, my lord,
Yes.
and second one is manual for procurement of work contract, my
So
lord.
it can be referred as a manual for procurement of goods.
My lord.
My lord, is written Manual for Procurement of Goods 2017.
Yes, yes, you have seen it. But then if you say word manual, it may include many things.
Manual for procurement of goods, my lord.
Anyway, we'll come back.
Issued by the Ministry of Finance, my lord.
We'll come back.
My lord.
May it please your lordship. Lordship,
Yes.
may I seek your lordship indulgence?
Yes, yes.
The last two items, your lordship. If this both the matter can be taken up tomorrow.
Who is the other side?
Other your lordship, I saw the concern of my friend.
Item 17. If it is convenient to this court, Your Lordship, I pray for let the matter come up on the 28th, Tuesday.
We will not give you a date. It is not possible. Its court is not giving.
Any date.
So giving indulgence means you have to give indulgence to everybody.
Otherwise,
It will come after a week only. After a week. Okay, item 17 on the request of Mr. Andy Chulai, Learned AG.
Then 16, your lordship, if it
List
can
after
come tomorrow.
1 week. Item. That is item 17, isn't it?
Yes, your lordship. With
Okay, now 16 will be
16 tomorrow, your lordship.
Your Lordship, on behalf of the petitioners, it may come up next week, Your Lordship.
let it go after 1 week.
Lordship.
Since 16 on the joint prayer of the parties, let this matter after a week.
Oblige, your lordship.
May it please your lordship,
Yes.
I beg to mention number 15. The standing counsel had an emergency, she had to go, so it may come up in the next date.
15.
No objection.
No objection. You are appearing for the.
Uh,
You are praying on behalf
the
of.
respondent,
Okay, on the request of the Lorded Counsel of the respondent. List this matter after a week.
I beg your lordship.
Lordship, may it please my lord, I beg to mention item 12.
See, you cannot have two mentioning session in a day. See, if you are accommodated, it doesn't mean that it should become a regular practice. Court should go by a certain procedure. Yes.
Whatever my lord feels.
Item number
12. 12 and 13.
12 and 13. These are connected matters.
No, my lord.
So 13 we will have it after 2 weeks. On the request of the learning council of the respondent, list this matter after 2 weeks. This 13. Then come to 12.
Yes, my lord.
2 weeks.
Okay, my lord.
2 weeks, my lord.
12 also 2 weeks on the request of the learning council for the respondents. Okay.
Deeply obliged, my lord.
Even today.
Yes. Well, I'll only read the relevant portions of the impugned order, my lord. At page 53 of the writ petition.
Yes.
At page 53, my lord, para 6 of the impugned order.
Para 6, yes.
Whereas, with reported allegation having stood verified, it became incumbent upon me as the competent authority to examine the relevant contract document, certificate, undertaking in question in the light of the relevant policies, rules being part of the bidding process, besides the true nature of such disclosure, such non-disclosure, and resultant impact on the contract. Accordingly, upon due consideration of various aspects, it clearly emerged that the tender document, both technical and commercial bids, as well as the financial bid, clearly laid down the manner of compliance. The bidders were contractually and legally obliged under the vinculum juris to furnish all correct information to qualify for the tender. The certificate in terms of Rule 175 of GFR 2017, as reproduced in para 3 above, in plain words was to the effect that the firm would not indulge in anti-competitive practice, that is to say any collusion, bid rigging, or anti-competitive arrangement or any other practice coming under the purview of the Competition Act 2002 between two or more bidders with or without the knowledge of the procuring entity that may impair the transparency, fairness, and the progress of the procurement process, or to establish bid prices at artificial, non-competitive level, or conflict of interest, that is to say participation by a bidding firm or any of its affiliates that are either involved in the consultancy contract to which the procurement is linked, or if they are part of more than one bid in the procurement, or if the bidding firm or their personnel have relationship or financial or business transaction with any official of the procuring entity who are directly or indirectly related to tender or execution process of contract, or improper use of information obtained by the prospective bidder from the procuring entity with an intent to gain unfair advantage in the procurement process or for personal gain. It was followed by an undertaking stating that if at any stage any transgression of this code of integrity for public procurement, the firm shall be liable to not only removal from the list of registered suppliers, but would be liable to other punitive actions such as cancellation of contract, banning from business, or action in Competitive Commission of India, and so on. It thus led to the obvious that the certificate of integrity for public procurement as per Appendix L of the tender documents by Sri Bhupinder Singh by no stretch of imagination could be assumed as accidental or inadvertent or unintentional, but an outcome of a conscious and deliberate act of falsification with full knowledge and intent to willfully suppress or a crucial information which would otherwise have disqualified the firm ab initio from consideration. The necessary corollary being the dishonest intention militating against the ethics and moral standards expected from a bidder, a conduct contrary to justice, honesty, modesty, good morals, and contrary to what the firm as a bidder owed to the society in general and to the Assam Rifles in particular. It further led to another obvious that the firm owned by Sri Bhupinder Singh and his wife Srimati Jaswinder Kaur are alter ego, and their co-participation in the instant tendering process could not be with any other intent than to obliquely keep the bid prices at artificial non-competitive levels to deprive the contracting Assam Rifles of the benefits of free and open competition, to overcome cycles of anti-competitive edict of the legislature. It all thus led to an unfailing inference of a conscious cohort in cartel fraudulent practice by Mrs. Lam Enterprise and the firm's attendant mens rea in breaching the terms of the subject contract agreement, the Integrity Pact, with the sole intention to make the bid favorable for acceptance as opposed to other tender conditions. Whereas the conduct of Sri Bhupinder Singh, owner of Mrs. Lam Enterprises, willfully and knowingly suppressing the spousal relationship with Srimati Jaswinder Kaur, owner of GSG Associates, amounts to a gross misconduct owing to a major fraudulent practice to obviate an essential qualification, not merely collateral. It was not proper to exercise any discretion or jurisdiction for me as the competent authority to accept its justification as advanced in allowing the firm to continue with the contract, particularly when confronted with a very basic question: what would be the fate if this spousal relation had been disclosed at the time of tendering? The only valid and emphatic answer would be that the tender would have been rejected at the outset summarily, since it was not in terms of the tender offer, being non-entitled. So long it remains undisputed, it does not serve as a valid justification for committing breach of a very vital condition prohibited without any discretion to any government authority awarding a contract. Thus, the clarification justification does not command me as the competent authority or undo the falsity of the certificate. So, well, that is the reasoning given by the.
What is the reason? It's you see inference. And then, just supposing your observation, what has been made in paragraph 7, that had there been a disclosure at the initial stage of tender, it would have resulted in rejection of the tender. On what basis? Do you say that the parties who are in close relationship are debarred from taking part?
Or you go back to the interpretation of.
See, these are basic inferences. That is why that me and you, we are brother. So if you are in fray in one arena, there will be presumption that we are in collusion. That is the basic thing what has been followed. But then if you go by the conditions stipulated in standard, you had not made any such condition saying that if persons are in close relationship, they are debarred from taking part.
That is true.
That observation based on what material?
It is not there, my lord. My lord, even if we, because that clause 3, my lord,
this
clause
paragraph
3
7
refers to Competition Act also, my lord. Even going by the Competition Act, I was reading the Competition Act, that particular definition, my lord. There also, if I may just point out that also, my lord.
Yes, when?
Section 3, my lord.
Yes, please.
Section 3, anti-competitive agreements.
Yes.
My lord, the heading of the chapter is chapter 2, my lord, prohibition of certain agreements, abuse of dominant position, and regulation of combinations, and prohibition of agreements. 3, anti-competitive agreement. No enterprise or association of enterprise or person or association of persons shall enter into any agreement in respect of production, supply, distribution, storage, acquisition, or control of goods or provision of services which causes or is likely to cause an appreciable adverse effect on competition within India. An agreement entered into in contravention of the provisions contained in subsection 1 shall be void. Any agreement entered into between enterprises or associations of enterprises or persons or association of persons or between any person and enterprise or practice carried on. A decision taken by any association of enterprise or association of persons, including cartels engaged in identical or similar trade of goods or provision of service, which directly or indirectly determines purchase or sale prices, limits or controls production, supply, markets, technical development, investment, or provision of services, shares the market or source of production or provision of service by way of allocation of geographical area of market or type of goods or services or number of customers in the market or any other similar way, directly or indirectly results in a bid rigging or collusive bidding, shall be presumed to have an appreciable adverse effect on competition. Provided that nothing contained in the subsection shall apply to any agreement entered into by way of joint venture if such agreement increases efficiency in production, supply, distribution, storage, acquisitions, and so on. So, it may not be necessary. Now,
Don't think these clauses help your case.
My lord, I admit, my lord, the impugned order, the speaking order should have been more particular on that.
No, whether in the impugned order, I think you have already said that there is no discussion about rates and all. Rate quoted and also not there.
They simply went on the basis only because they are husband and wife, my lord. They would have been, if they disclosed this, they would have been disqualified right at the beginning.
But then on what basis you said
it? I admit to them, my lord. There is nothing.
Now, you may have said it, but then there has to be a basis of saying
There has to be some basis, my lord.
this would definitely, had there been a condition incorporated in your tender, in the terms of conditions of your tender, that person in close relationship are debarred from taking part. In such a case, definitely.
But there cannot be such relation, my lord. There are many cases where
definitely it has to be basis of the individual rights.
There can be fair cases of close relation also.
So that is why you see, it is not only that you can take a decision just on the basis of the establishment of relation. You have to go a step beyond. And to find out
the one person was in a position to influence.
Yes.
To that effect, in my humble submission, there is no finding in the speaking order. They've only gone to the extent that the alter ego, and they've used some phrases there. Obviously, they say that unfailing inference of a conscious.
No, what is unfailing inference? Everything is is to be based on inferences. Then again, it comes back to the same thing. Just because they are in relationship, you see, they are divided.
Disqualified.
The biggest problem is that you have not filed an affidavit of opposition. Now that is what you see, like it has to go on record.
But my lord, the affidavit could not have been improved if the speaking order is there.
Anyway, but then whatever you say and what has the main basis, this could have been reflected there.
But since that is not reflected in the order itself, my lord, by affidavit we cannot improve the speaking order also, my lord. But only thing is that because of the delay in the time, my lord, and in the meantime the project has been cancelled entirely.
We are not going to in that aspect. We will just confine our thing only to the blacklisting part, nothing else.
In fact, I almost convinced them. The only query from them was to me, my lord, that if that is set aside, that our entire case of the termination will go, might be prejudiced.
Because termination is now irrelevant in view of the scrapping of the.
Because if you admit to that, my lord, then they may claim for compensation, my lord.
No, see, in view of the fact that a petitioner is also not pressing on that part.
My lord.
Okay, so termination becomes irrelevant now.
My lord.
The only thing remains is that blacklisting. And as your own rules say that at least so far as the tenure or the period for which he has been blacklisted could not have been more than 2 years.
Could not have been more than 2 years.
In that view of the matter, to that extent, this order is incorrect. And another thing, whether you can go into the things which is not a part of your allegation in the show cause notice.
In fact, I thought of filing an affidavit, but again the question was, if you file an, can I improve the speaking order by affidavit? Okay, cannot. The speaking order is a detailed order.
No, but then your silence would mean admission. If you go by the provisions of Evidence Act. Section 3(1) is not helping you.
That is also in the almost something more than that is required, my lord. More than a relationship, my lord. There must be this fact be established that they are in a position to dominate or control each other's, or I can influence that. No, you don't quote 1 crore, you quote 1 crore 5 lakh. Now that we don't have any material to say that.
At least you have not discussed. You see, if you had discussed also, and then if you had said somewhere that has been quoted that way, then maybe you would not have gone to the merits of the decision. At least you have said that you have dealt with the issue. But then here is nothing to show that dealt with the issue. Yes, Mr. Day, you were supposed to point out something from the records.
Yes, my lord, we have figured it out. The letter is the star mark in the flag in file number 3, my lord, page 49. After the complaint was made, my lord, then CVC's comment was asked for, my lord, and they have given a comment. And my lord, this will help my case, in fact, my lord.
Is it a big report, that CVC thing?
No, no.
Can you have a copy? Because of this entire record, this
No, it is 4 to 5 pages only. And I'm relying only on 1 page. His opinion of CVC was sought, and they have given the opinion.
And this opinion favors you?
Yes, opinion favors me in a sense, my lord. They say that separate entity, my lord, they can participate. There is no problem on this. So that is my case, my lord. Moreover, what my lord, it has fallen from my lord that they cannot improve their case. There is judgment of the full bench of the Supreme Court, my lord, in 1978, my lord, AIR SC. So this is a full bench judgment where they said, my lord, you cannot improve your case. Whatever the court has to decide.
8, not International Airports Authority, no.
No, my lord. This is
International Airports Authority is
yeah.
something.
Gill versus election. Yes. Mahendra Singh versus Election Commission of.
Yeah, this is on a different context, Mister. Not on the contractual.
No. What was my contention is this: is it may be in the different context, but what they.
Yeah, these are settled law.
This is settled law, my lord. This is settled law.
Even Dr. Mojika is also not disputing that proposition.
Yes. So, my lord, senior can Xerox and supply it to the court, my lord.
If it has a relevancy, then
It has the relevancy, my lord. This is my understanding.
My lord, the way hearing is gone, I can provide a copy, my lord, but I can provide a copy. No problem. Well, actually, what happened, my lord? I'll just because the Paramhans, my lord, who was disqualified at the technical stage, first he wrote a complaint to Ministry of Home Affairs, my lord, not to Assam Rifles, my lord. From Ministry of Home Affairs, a letter came to us forwarding that complaint, and they asked a clarification from us. So that time we sent this reply to Ministry that, and we initially we said that only because they're husband and wife, it may not be a disqualifying factor.
subsequently change your opinion. Was it by the same this
Same person, second complaint, my lord. Again,
no that forwarding of your comment by the ministry, was it by the same person who passed that impugned order? No.
No, my lord. Impugned order is passed by Director General. Impugned order is by Director General of Assam Rifle, my lord. At page 56, your lord. Yes. And this was by Brigadier, my lord. It was much below Director General.
This was. No, criminal complaint there is a stay with regard
There is
to
a
that.
stay, my lord. And they have also in a submission, they are not going to insist on this, my lord.
That we've admitted, my lord. Lordship process that also, no problem. In fact, criminal complaint has not been filed, my lord.
For fraud.
We have not filed, my lord.
For fraud.
For committing fraud against the Assam Rifles. Non-disclosure is a fraud. Yes, anything more? cancellation of contract is also by the same impugned order.
Yes. Yes. Hmm?
It is flowing from the reverse side.
Lord, I had brought 3 decisions, my lord. Only in that line only that there cannot be direct evidence. It can only be drawn by inference.
It's okay, but then what evidence you have recorded? That is the main thing. Tell us about indirect evidence here. Except for your inferences.
Well, evidence was there, but it's not reflected.
Surmises and conjecture,
Because
which
the price was so close, my lord. The price was, but that's not reflected in the order. If that was reflected, I had a good
it's
case.
not available in environment. Where is the question of going to price? And since it is not a basis on which you have passed the order, why should we go into price?
But that's what, my lord. If it was reflected in the order, if order was well prepared.
Price, the question of price, this court is not going into it because it is nowhere pleaded. It is not in the your impugned order, nowhere in shock cause, nothing, nowhere.
If it was there in the speaking order, my lord, impugned order.
Things would have been different that way.
Things would have been different.
Your inference could have become stronger there.
My lord. And another aspect that has also not been discussed, my lord, in the impugned order is that the complaint of Paramans said that husband and wife bid at very high price than the normal market price.
Then why you have accepted that?
The complaint came after we accepted, my lord.
Now someone has participated in the process and he failed, my lord. Now he filed a complaint and they act upon that, my lord. Whether they was in the dormant phase, my lord, that someone has to charge them.
Whether this complaint was this thing furnished to him, copy of the complaint?
No, my lord. No.
Now, is there anything to show that this action was initiated on the basis of the complaint?
No, there is nothing, my lord.
Nothing on the record
Nothing,
to show.
nothing. No, my lord.
Now then it's nowhere in your environment.
No.
You did not know probably at the time when you filed it.
Yes, my lord.
Who was the complaint, you said?
Paramans, my lord. Messrs. Paramans. Full name will be, my lord. Okay, show the file. File 1.
File 1, give him file 1.
Yes, sir. Paramans.
In the list of this one.
Paramans Technologies, my lord.
And when was it filed?
There was 2 complaints, my lord. The first complaint is on 12th February 2019.
These complaints are not a part of this record.
No.
Anyway, now this is after their bids were rejected, isn't it?
Yes, exactly.
Before that, they did not raise any.
No, they are not.
No, it's a fact that department also did not doubt anything wrong till that complaint came. Yes, anything more you want to say?
Just one more thing, my lord. Since the complaint is now the subject matter, what my learned senior has pointed out. My lord, the first complaint, my lord, we can consider the first complaint, which was filed by this Paramhans, was on 12th 2nd, 2019, my lord.
12/7.
12th 2nd February, 12/2/2019, my lord. And here, my lord, they have not mentioned that we are husband, wife, or anything as per my learned senior's submission, what I could have get for his submission, my lord. Subsequently, my lord, there was a second complaint. The second complaint was on 6/5/2019. 6th May 2019. Now, my lord, 6th May 2019. And the side was handed over to me, my lord, on 3rd December 2019.
After that?
After a period of almost 6 months, side was handed over to me.
Anyway, these are... This court will not go into those
My lord,
arena, you see.
my lord.
Now that criminal complaint will not be filed, that can go, we can record it as your statement. Well. Anything more?
That's all.
We'll reserve it then.
Lord, only thing, my lord, they are saying that they've done some work for them, for which they want to file a civil suit, my lord. Our case is that we have paid him advance, he has not done any work.
My things are lying down, my lord, in the Assam rifle.
So that
It's all iron made.
Yes, that is what the order says.
Yes.
That your things should be kept in safe custody.
No, it has been kept open, my lord. It has been rusted now 4 years, my lord.
That the order says. So that shows that your things are there.
Yes, yes, my lord. And that I have paid 1
Anyway,
one
the
crore
court is not
GST
going to
also.
make any of these things. This will be open for the parties, probably. You see, like to pursue whatever the outcome of the thing.
My lord, only my lord, that civil suit which we have already filed, which they are going to file, my lord. Any observation by this honorable court will not prejudice that, my lord.
The court will not give any observation with regard to that. Is it required? I don't think. You have already filed a civil thing.
Yes,
Okay.
my lord. As
So far as your claim of recovery is concerned.
They might claim compensation over and above the goods supplied, my lord. So that they have to establish.
So now, my lord,
that will definitely be subject matter of determination of that case. Until and unless that is decided, their claim also may not be entertained.
probably they have realized, my lord, they have committed a mistake. Now the fear is there, my lord, of compensation.
So, Mr. Day, matter would have ended like that if this order was
They
required.
are very arrogant, my lord.
That
They
would
have
have
not.
been. Anyway, it is according to them. Then if they
But if
record,
they-
then
if
the
they
very
had-
basis of their order will go.
My lord, had they argued this matter in 2020, my lord, they would have got the contract, my lord.
I was not the counsel, my lord, at that time. That my lord would have not. Now also, my lord, if they want to give, my lord, I am ready to complete the
Now
project.
this has been abandoned.
Your civil suit also will be decided once you give them. And confirm.
Deep.
Please, Your Lordship.
Yes.
Well, here the finding of the BSF code is under challenge. I think
It is akin to a criminal appeal.
It is almost a criminal appeal, my lord. But the only thing is that my lordship will not reappreciate evidence. But my lord, I'll bring a judgment which shows that my lord can go through the evidence also.
If you do not reappreciate evidence, then what can be the basis of making a decision?
Well, generally, my
First
lord, what they say the
reconsideration.
scope of judicial review under 226 in such cases is, my lord, whether the procedure has been followed or not. Apart from that, my lord, there are judgments, recent judgments of the Supreme Court, which says that, my lord, we cannot just overlook. If there is no evidence, then the court can look into evidence also. But my lord, today I don't know whether we have time to, my lord, do the entire hearing. Just one aspect of the matter which I want to point out, my lord, which is very important here is, if my lord will just see this judgment of High Court Division Bench. My lord, here in this case, what has happened is that, my lord, after the finding, my lord, there is a provision for filing an appeal, like a statutory appeal, my lord, before the relevant authority, my lord. My lord, that appeal was decided by an authority which did not have the power to decide it. And that subject matter has been decided in this judgment of the division bench, my lord. If I will just read out, it's a very short judgment.
Yes.
Lord, I'll read the entire 3-page judgment.
Yes.
The principal ground urged by the writ petitioner in assailing the order of the punishment inflicted by the security border courts of the Border Security Force is that the review preferred by the petitioner was not appropriately dealt with. Indeed, it is rightly pointed out on behalf of the respondents that Section 117 of the Border Security Force Act 1968 provides for a petition being filed against the confirmation of an order of punishment. Such petition, according to the writ petitioner, was filed before the Director General of BSF, but the response to the petition was issued by the Chief Law Officer of the force. Section 117, Clause 2 of the said Act mandates that any person who considers himself aggrieved by a finding or sentence of any security force code which has been confirmed may present a petition to the central government, the Director General, or any prescribed officer superior in command to the one who confirms such finding or sentence. It may also be noticed that the remedies of the provision requires the authority in receipt of the petition to pass such order thereon as it or he thinks fit. On any plausible interpretation of the provision, it is evident that Section 117, Clause 2 of the Act affords a remedy to the person aggrieved by any finding or sentence passed by the Security Force Code that has been confirmed. The corresponding obligation affixes the authority that it is petitioned by be it the central government, the Director General, or any prescribed officer. In other words, the authority which is petitioned has to apply its mind to the matters in issue and, upon due consideration thereof, communicate a reasoned order to the petitioner within a reasonable time. Any other interpretation as to the obligation of the relevant authority would render the remedy to be illusory and not meaningful or effective. In this case, it was the Chief Law Officer of the force who communicated the writ petitioner herein that his petition to the Director General of the force has been rejected. When a remedy in the nature of an appeal or revision or review is provided for by a statute, the appellant or the petitioner seeking revision or review has a right for his grievances to be appropriately assessed. Such grievance may be seen to be appropriately dealt with only when it appears that the authority before whom the matter was carried applied its mind to the matters in issue and dealt with the grievance in accordance with law by passing a speaking order. Of course, a statute which gives may also take. It is perfectly permissible for the statute to require even a non-speaking order to be passed. However, a non-speaking order would be an exception and not the rule. Thus, unless the statute which grants the remedy expressly provides for a non-speaking order to be passed, the matter has to be dealt with by a speaking order. Since the writ petitioner's petition under Section 117, Clause 2 of the said Act, in this case does not appear to have been appropriately dealt with in accordance with the law, the writ petition succeeds and the order communicated to the petitioner by letter dated 22nd June 2015 is set aside. The petition will be considered by the present Director General in accordance with the law by keeping in mind the observation above. It is made clear that the merits of the matter have not been gone into. WBC such and such succeeds to the limited extent indicated above. It is hoped that the speaking order of the Director General of on the petition under Section 117 Clause 2, fine, my lordship has gone through it. So my lord, basically my case is exactly the same. The post-confirmation, my lord, my appeal was dealt with by the Chief Law Officer. Now, well, there is already an order of the division bench. But my lord, this is not the only case I have. My lord, my case is that, my lord, there is an accusation of rape, of sexual assault, my lord, made by the wife of one of my colleagues. Now, my lord, here, my lord, lordship will go through the evidence. My lord, there is no case of 376 made out at all. On evidence, there is nothing. My lord, it is a very clear-cut case. My lord, these two people were having an affair. There are SMSs exchanged between the parties. My lord, in fact, the victim has invited the other party by sending an SMS. Well, but apart from that, my lord, this is a major flaw, which, my lord, the division bench has already dealt with, my lord. And in my humble submission, my lord, the order of the
if you are satisfied with this order, this court will follow that same order. Yeah.
But my lord, there is another catch here. My submission is that, my lord, this order, my lord, has merged with the finding. My lord, the doctrine of merger will come into play here, my lord. So if this is set aside, my lord, the entire finding also has to go.
If this is set aside means?
Well, I mean, if this, my lord, if the order of the post-confirmation, my lord, is set aside, my lord, then the finding on the basis of which I file a statutory appeal will also go, my lord. The doctrine of mercy will definitely be applicable here, my lord. Because I file and, my lord, the authority provides for a provision for an appeal against a finding of a court. My lord, in this case, the finding of the BSF court. After that, my lord, I can file an appeal before the higher authority. The higher authority has rejected my appeal. So, my lord, basically the finding arrived at by the court has merged with this order, my lord, which is under challenge.
No, you see, if you see the very basis on which this division bench order was passed,
my lord,
that's something by consideration of your petition by a subordinate authority and not by the authority to whom
it lies.
Yes, that is the main thing. The order is
my lord, that is not the only case I have, my lord. Well, what I am trying to say is,
see, that order of that appellate authority or whatever authority you say, it was interpreted and sent back to them.
My lord, but my lord, that will not serve my purpose over here. Well, I am just pointing out one particular aspect of my argument, my lord. Apart from that, my lord, like I said, my lord, there is no evidence in this case. If lordship will once go through the evidence, my lord, lordship will not require to reappreciate evidence. Lordship will come to a finding that there is no evidence at all. And in such a matter, well, a similar matter, the Supreme Court, in fact, in a matter pertaining to the BSF only, the Supreme Court has said that, well, even though in the petition under Article 226 challenging the finding of the BSF court, the court generally would not reappreciate evidence, but the court will not close its eyes totally if there is no evidence at all. So, well, that is the case I have. But, my lord, today perhaps, my lord, because the paper book is quite thick, we will not be able to go into the evidence. So, my lord, this matter can be taken up next week.
It's okay. We'll go on. Definitely, there will be no time for
and
us.
Also, my lord, my another aspect is, my lord, the punishment given to me is for 7 years. I've been inside for 30 months, my lord, as on today. Almost, my lord, more than 2 years I have served my sentence. My lord, my miss case for suspension of sentence is also pending. Well, even if that can be considered, my lord.
Once it is for final hearing, why should we do it in piecemeal?
Well, if the matter can be taken up next week.
Suspension, it has to be decided on the basis of merit.
Well, on merit or otherwise also, my lord, if my lord, considerable amount of time has been spent inside.
The Supreme Court says the suspension is on the basis of the prima facie. If there is a likelihood that you may be. So, you have to go into merit.
One prima facie point I have pointed out already, my lord, before lordship.
That is, you have pointed out, but then what they will say we do not.
Well, absolutely, my lord. So, my lord, let this matter come up.
Supposing if it is refuted by them, then you have to go into evidence.
Yes, my lord, absolutely.
To see whether there is.
In this case, my lord, we will have to go to see the evidence, my lord, at least. Whether lordship will reappreciate or not, my lord, that I will leave it to my lord.
No, but then see, going to evidence, will it not amount to reappreciating?
My lord, there are two ways of looking into it, my lord. Basically, my lord, when the finding has come on the basis of an evidence, on the basis of evidence collected during a trial. My lord, let's say it's not a trial per se, a criminal court, but it is a trial at the end of the day, on the basis of which, my lord, the Indian Evidence Act is also followed by them. And, my lord, on the basis of which they came to a finding and they have punished me. So, even if, my lord, under 226, my lord, if lordship cannot reappreciate the evidence, but if my lord will go through the evidence and come to a finding that the entire finding is wrong, there is no evidence of a particular offence made out, then, my lord, of course, lordship can take it.
Perverse.
Absolutely perverse, my lord. Absolutely perverse. Absolutely unreasonable.
If no evidence at all, my lord.
Yes, that is what. If there
is absolutely zero evidence, my lord, in that case.
Zero evidence, my lord. If I am accused of an offence of 376, my lord, and my lord, it is proved even during trial that I was invited to somebody's house, and my lord, there are witnesses saying that these two people were having an affair. Then, my lord, of course, lordship after going through everything will come to a finding that there is no evidence.
Even in spite of that also, there can be commission.
But their case is they send a WhatsApp message.
Go by your statement. You were invited. You were having a relationship also.
But, my lord, then what lordship will see is the variance in the statement given at different times, my lord. The improvements made by the.
Then again, you will tell us to reappreciate.
So that will not exactly be reappreciating, my lord, but just going through the different stages. My lord.
Now, is it correct that this is also that petition after the conviction or the appeal, whatever you say, filed under section 117 sub clause 2, was decided by an authority?
No, my lord.
Not to whom it was addressed.
The instant case is slightly different.
The law says that it should be decided by an authority who is higher than the authority who passed the sentence.
My lord, it is the Director General of BSF, my lord, who is the appellate authority, where 117 lies, my lord.
Yes.
But there are several decisions of Supreme Court, my lord. But the earlier case was slightly different, my lord. Here, my lord, the order, though communicated by a law officer, my lord, in the present case, but he has clearly mentioned the Director General is of the view.
Okay, so he is only the communicating authority, my lord.
No, but my lord, it's absolutely similar to the previous case, my lord. There also it was the same thing only. It was signed by the Chief Law Officer.
My lord, in the previous case, which was pointed out.
Order is signed by the Chief Law Officer.
Yes, my lord.
My lord.
As per my understanding,
because Supreme Court says, my lord, the Director General is not required. He only has to. Because normally what happens, my lord, he has to deal with
thousands. So this division bench order is contrary to Supreme Court order?
No, my lord. if Director General has applied the mine, my lord, that was the case where Chief Law, there is no reference that Director General ever applied his mind, my lord, in that case. Chief Law Officer, he himself wrote the
Can it
order.
be something like that? You apply mind and I pass the order.
My lord, there are Supreme Court decisions to that effect, my lord.
What does it say?
It says that
it says that it would be all right.
It will be all right. It will be all right, my lord.
Whoever passes the authority, but then it will be enough if it is reflected that DG has applied his mind.
DG has the matter was discussed with DG and everything was.
You have the
told.
decision with you.
There must be some minutes also to show.
I'll place it.
No, that definitely will place at the time of use.
Well, there has to be something to show that mine was also applied. Well, here it is.
And so much so, my lord, and so much so, my lord, the Supreme Court has even said that even a speaking order is not required.
Well, that I agree. 117.
Even two-line order is enough.
That I agree, my lord. There are decisions which says that under that 227 not
In your
required.
case, what is the statement of the victim?
Well, statement of the victim first made under 161 is that, my lord, this person.
161.
Well, she has.
Just tell us one thing: the procedure before a BSF court.
No, my lord. Here, my lord.
What?
Initial FIR before police, my lord.
Charge sheet filed.
Charge sheet filed before police, my lord.
Yes.
So 161, 164, everything happened before the normal court, my lord. And then we filed Section 80 application to
Claim the trial. To claim the trial.
claim the trial, my lord.
By a civil court of
And
procedure.
then the trial was held there. The charge was framed where?
Charge will be framed by the BSF court, my lord.
So that was your claim of trial was before that.
My lord.
Now, when matter comes to BSF court, what are the procedure to be followed? The same CRPC, what the CRPC says, or
the
Evidence Act is there, my lord, followed. Of course, they have a slightly different procedure. They
BSF
do
rules,
the
my lord.
record of. They have a set of rules. The record of evidence is prepared first, and thereafter, my lord, the trial is conducted where witness is called, examined.
record of evidence means that the charge sheet and this thing.
Subsequent to that also.
161
they do it again.
statements.
They do it again, my lord.
That is what the record of evidence it should be.
My lord, in fact, there are.
Who prepares the record of evidence then?
My lord, in fact, there are three stages, my lord, in the armed forces. One is court of inquiry. There also all the witnesses are summoned, they're examined, my lord, cross-examined. Then if a prima facie case is made out, my lord, then record of evidence is prepared, my lord. Then again, all the witnesses are called, my lord. Then, if again...
By the same, it will be before the same authority. Court of
different
inquiry.
authority, my lord.
Court of
by a different authority, record of evidence will be by another authority, my lord. And then, after record of evidence is prepared, it is placed before the competent authority, then he has to go through it. Then he sees that yes, there is sufficient material. Then he sends the matter for trial before the BSF court. And then again, all the witnesses are called, my lord. So there are three stages.
BSF court is what? That is not called by anything, court of inquiry or court of trial or court of nothing.
But this is not a permanent court, my lord.
It is convened.
But these courts are convened on the case-to-case basis, my lord.
Then,
so whenever any offence
when the court is constituted, once record of evidence is prepared, and the higher authority gives a green signal
to
proceeding
proceed.
trial,
Yes.
then the court is constituted and the trial is held.
Then
Now,
again,
in
all
the
the
trial,
witnesses-
in the trial, what process is followed?
Again, the BSF rules, but there is a detailed process, my lord.
But Indian Evidence Act is also.
Is it? No, that is so far as the appreciation of evidence is concerned. But so far as the procedure is concerned.
Procedure, they have the rules, my lord. They have the rules.
Is it akin to CRPC or not? No.
More or less, my lord.
More or less similar, my lord.
There is a requirement of framing of charges.
Yes, my lord. framing of charges, summoning of witnesses,
Pleading guilty, not guilty.
pleading guilty, not guilty, cross-examination, re-examination.
Cross-examination.
More or less same process, my lord.
If cross-examination, re-examination will coming to evidence act.
My lord.
That is provided in the evidence act.
Yes.
So once evidence act is applicable, yes.
I think BSF
Then
rules.
what about this 313? Everything is there.
Well, look, 313, yes, my lord, it is there. But in this case, the accused chose to be a
313 is not
witness.
provided in the evidence act. It is in the CRPC.
Yeah.
It is in the CRPC. No, my lord, not exactly 313. You're allowed to bring defense witnesses, but in this act, the accused person.
What about the
himself-
accused his own statement?
His statement, I don't think so. I have not seen that. 313, because perhaps 313 is not.
That is not there. That is a basic in criminal law.
But here, my lord, what has happened is he has come as a witness, but 313, I am not aware, my lord. I will have to just go through it one more time.
See, this court has not dealt with those things. You have to place it
Absolutely, my lord.
properly.
Absolutely. For me also, it's new. But what interesting thing I found is, my lord, in such cases, my lord, the accused is always already prejudged. Because, my lord, of course, it is a force where, my lord, this person is morally very wrong. But when it comes to an offence under 376, my lord, no evidence is made out. There is no case made out. Morally is wrong, my lord. So on the mind of the court was that, my lord, being a member of the force, this person is morally wrong, so he has to be dismissed from service.
But when victim says, my lord, that I have been raped, we'll go by the version.
But, my
of
lord,
the-
that
said that.
my lord, that has to be judged on whether we can take it as a gospel truth or not.
He is taking, my lord,
Now
that's
again you are coming back to the same thing, appreciation, reappreciation.
Well, somewhere or the other, my lord, a man has been punished for
His
7
case is,
years.
my lord, there's
Apart
a-
from that, he's been dismissed from service. This is the maximum punishment a man can get, apart from a death penalty, my lord. So, my lord, if the finding is on the basis of something, my lord, which the victim says she has been raped, well, we look at the circumstances also, my lord, here. The conduct of the victim prior to the filing of the case. Well, the conduct of the complainant. Well, there's so many things. In fact, in the ROE, my lord, there's one particular witness, an independent witness, who says that I was aware that these two people were having an affair. I have seen them chatting. I have seen them, which totally points out to two people having an affair. But that particular witness is not brought during the proceedings, my lord. He's not called.
No,
I'll point that out.
even say supposing this person was called, his deposition would be on to that extent only.
Absolutely.
To say that they were meeting together, they were having good relation and all those things. Nothing beyond that.
No, my lord, absolutely correct. What Lordship is trying to say, I do understand, my lord. But when the woman says that she has been violated, my lord, of course, the law says that our sole testimony is more than enough. But there are certain guidelines for us to see also whether we can absolutely believe on that sole testimony. So that is what I'll point out, my lord.
So now, as you say, you see, in the criminal rate, our jurisdiction is confined.
It is confined, my lord. But it is confined.
Like it not be as wider as
Not
the
as a
criminal
criminal
appeal, where we have to reappreciate the evidence.
Not as the criminal.
So there in this case, no duty is cast on the court to reappreciate the evidence.
That I concede, my lord.
Okay, what is provided in section 386 CRPC will not be applicable here.
Not
the
at all.
duty of the appellate court and all. Okay, now if that be the thing, then what Dr. Mujika says it is correct. Once there exists a material on record, that would be enough. We would not judge the sufficiency of that material.
Well, Lordship, that is correct, but my lord, if Lordship will once go through the evidence and Lordship sees that this person has not been appropriately dealt with by the court, my lord, the BSF court, then Lordship has every power under Article 226 to interfere, my lord.
No, that is
their case at the most may be of consensual act, my lord. Now, consensual.
It's
It
not a
was
POCSO case, consensual, and how do you say it's?
to get rid of rape charges. They have to establish it was by consent, my lord.
This thing is a POCSO matter.
It's not a POCSO matter. my lord.
Then
No, 376.
the once you can establish it is consensual, then
Well, there are
definitely
WhatsApp messages. 3 बजे आ जाओ, 4 बजे वो चले जाएंगे.
you adduced your evidence.
My lord, I came as a defense witness myself, my lord. But those things are a part of the paperwork I have prepared, my lord. So, well, I think today perhaps will not be.
If you come as a defense witness, oath has to be administered.
Yes. Then that evidence can be taken against me also, my lord, whatever comes out. So, well, we can have this matter next week, my lord, because I have
Yes,
been
we can have it. There is no dispute these things. Just trying to get some idea. It's a new subject.
Yes.
So just trying to learn something from you.
But what I'll do, my lord, even for me, my lord, 1 or 2 cases come in a year, my lord. And I get confused between army rules, my lord, and Assam rifle rule and BSF rules, my lord. so what I if
These are not identical. It's all almost
Quite
identical.
similar.
rule numbers are different, my lord.
Quite similar. The acts and rules.
Rule numbers are different, my lord. There are so many rules. So, my lord, I'll check the date when it was fixed. I'll call some BSF to assist me which rule and where, my lord.
Well, but I have gone through certain judgments, very recent also, my lord, of the Supreme Court. In fact, in that case, the person had confessed. But even then, the Supreme Court said, even if the person has confessed also, there are certain parameters which have to be in place.
Yes, because it's a liberty of a person.
My lord,
There is
also in most of the cases, they are always dismissed from service. Here, my lord, 7 years plus dismissal.
And my lord, I do not know whether he pleaded this case or not. One very interesting question in all these paramilitary forces is that, but there is one section of Assam Rifle Act, also BSF Act, that following punishments can be imposed. Number 1 will be death. Second will be 10 years imprisonment. Third will be, for example, dismissal from service.
Yes, I have gone
Now,
through
whether 2 sentences can be imposed from
That is it.
that is
here
also
he has
very
been
interesting.
given 7 years imprisonment
Along
and,
with dismissal.
and dismissal from service.
Basically, because I have been convicted
By
for
the same
moral
authority.
turpitude.
It will not by the same authority.
By the same court.
That is what. Yes, like in a normal laws, a department can dismiss somebody and the criminal court can convict him. See, there will not amount to double jeopardy.
Upon trial. The trial will be done by criminal court.
Yes. Now say like for outside these things, those force laws and all, a person governed by normal laws. He happens to be a government servant. For the same offence, department can dismiss him from service. At the same time, criminal court can convict him. For life. That will not amount to double jeopardy. But then here it is by the same authority.
The same. While pronouncing the judgment, the BSF court said that number 1 sentence is 7 years imprisonment, rigorous or whichever way, and number 2 is your dismissal from service.
Now,
that is as per the rules of the BSF.
yeah, so that they can.
Because, my lord, I am
there is no bar
accused
for
of
that,
a
I think.
criminal offence of moral turpitude, so
That
automatically
may
the moment
require
is convicted.
that may require some
I'll
examination.
look into that also. That's an interesting.
That may require, because 2-3 cases.
Your action, why do you need interpretation? You have done it and you will boldly say we can do it.
No, my lord, it is a long-term matter, my lord. This aspect.
Anybody raised this issue before any other authority?
The rule
In one of the matter it was raised, my lord, but that was somehow.
Now, do you want to say, like in a criminal case, if a person is convicted, if he is sentenced, then he cannot be dismissed from service, or if he is dismissed from service, he cannot be sentenced.
My lord, when I put this question to the Assam tribal people, my lord, because they came from army, they come on deputation, my lord, for 2 years, 3 years. He said, in army rule there is one provision that if somebody is sentenced to more than 3 months, that automatically he will be dismissed from service. Now, whether such clause is there in BSF Act or Assam
No, but
Rifle
then,
Act,
even if it is automatic, okay, that will take place when the situation comes. But then, who order same thing with the same order is something different. Say, supposing if something is automatic follow-up, then it is not required to be reflected.
yes,
Dr. Mojika is convicted for life, that will
automatically dismissed. from
result in
service.
his dismissal from service. But then here in the order you say that you are dismissed from service as well as convicted for life.
I think that was the case in the judgment you placed just now, the Hajong. There also life imprisonment and dismissal from service.
life imprisonment automatically will be
Judgment by Supreme Court.
division bench. My lord.
By the division bench. That
The
my
one
friend
that I read
placed
out, my
just
lord, just
Acha, this is that
Director General.
Pradeep Kumar Ajam.
Yes.
No, but then that the court has not gone into all those aspects.
not gone into the merits.
Only it said that it is decided by a subordinate authority, communicated by a subordinate authority. So,
Just change the signature.
No, that was done, and they again came by way of writ petition. Even that has been dismissed. So now is
well, that is dismissed.
So they came back again after that.
So that means that is there also same thing. Dismissal from service as well as conviction.
But this point was not taken by them in that way.
Here also they have not,
Because the life imprisonment may stay in a different protocol, but he is not available to serve also.
no, but then you see by application of normal service law, if a person is convicted by criminal law, that will result in dismissal.
Yes.
Even in service law also it is like that.
But
you do not have to hold any this thing departmental proceeding for that.
they can wait for the criminal court to decide. Once the criminal court decides, and automatically they'll
In that logic only is going well. I just though this
I don't
is
think that we have to go
relevant
into
here.
that arena. Anyway, we'll have it. We'll have it after 2 weeks. Next week we have so many matters.
My lord, 2 weeks then. My lord.
2 weeks.
Well, on the joint request of the parties, raise this matter after 2 weeks. What to do about this copy of the thing? You punish it at the time.
I'll take it back, my lord. Place it in.
Thank you.